Okay. I'm Steve Schenfeld. I work as the writ attorney in the Iglesias firm, for those of you who don't know me. What happened, as this all came about, is that we as some writ attorneys had been up in Sacramento for a conference up there. And we decided that there was a need for attorneys to kind of get a better grasp on what cases to cite for what purpose. Reading the transcripts that we get, even if it's just a file that one of our clients, a writ that one of our clients has sought, we still read the transcripts and see what other parents' attorneys are arguing. And what we decided is that we would just want to get some kind of message across so you all can kind of take a feel. So when you're just preparing for that real trial that you do, where you have the witnesses coming in, you're able to just put aside all the noise and just focus on that one file and understand what cases you want to cite to the court for what specific reason. It's not always just causation. Sometimes you're arguing substantial risk. Sometimes you're going to be arguing serious physical injury. And there's a case out there somewhere that is just focused on that particular point. So what I wanted to start off today, as you can see, this first section, that has to do with subdivisions A, B, C, and G. And so the case that everyone always remembers is the Ana Gonzalez case. And the reason we all remember that is because it had to do with the wooden spoon. What happened in that case is that the parents had a daughter who was first just not doing her homework, then she was starting to hang out with the wrong crowd, then she became involved with gang culture. Her texts to her new friends were somewhat unsavory. The parents started to have an increasing level of discipline with their daughter. First it was talking to her, that wasn't working. You know, her iPod and iPad were taken away from her. That wasn't working. Keeping her away from her friends, she would still sneak out. In the meantime, her grades were falling and falling. So parents decided we're going to have to move up to the next step of actual physical discipline. The girl was about 12 or 13 years old at the time. They decided, the father did, and they told her what was going to happen. They were going to hit her, physically discipline her, using a wooden spoon. She was hit. She went to school and she showed the marks on her backside to the school nurse. The school nurse called the department. The department in Santa Clara came out and investigated. This was a 6th district case. And what happened is that they brought a case for CACI, Child Abuse Index, that we all hear about, the CACI hit. CACI exists under the CAMRA, which is Child Abuse, Neglect, and Reporting Act, which involves some criminal penal code statutes. Well, they went in front of the board up there where the administrative law judge sustained the CACI, and the parents took a writ of mandamus to the Superior Court. The Superior Court found true the findings of the administrative board. The parents appealed that, and that's what resulted in Gonzalez. But Gonzalez was not just that kind of case. For Gonzalez, as you can see, ended up having to do only with a criminal case, because CAMRA involves the penal code. It is not a dependency case, and for that reason, it's not always the best case to cite. I know some of you have been successful in arguing that if you hit with a wooden spoon, as long as it's reasonable discipline, even if a mark is left. But let me just tell you that there is a case, unpublished, called Destiny C, which the county council has asked the appellate court to publish. The appellate court responded that it didn't want to and sent a message or its letter up to the California Supreme Court. The reason the county wanted this case published was because Destiny C, the court wrote, the Gonzalez court held that a genuine disciplinary intention can furnish a bar to finding of child abuse under CANRA when the circumstances present a reasonable occasion for discipline and the discipline imposed is reasonable in kind and measure. But the court concluded we cannot say the use of a wooden spoon to administer a spanking necessarily exceeds the bounds of reasonable parental discipline. But then the Destiny C court said Gonzalez did not mention 300, much less apply it. The court's conclusion about hitting a child with a spoon, therefore, does not apply to this matter. There's real question whether the appellate court, if Gonzalez is the only case you cited to, is going to really have an impact on the result of the case, because it's based in the CANRA, and that relies on criminal statutes, where the intent for a criminal case is to do harm to a child, to cause excessive physical problems. And that is not what dependency is about. So the case that I think we should cite to is the 2014 case that I noted for you today, Isabella F. There, the daughter again was increasingly becoming belligerent. She wasn't attending school, she was cutting classes, her grades were dropping. She had some dispute with her brother about some money he had given her for chocolate milk, and she was supposed to pay him back. So while they were fighting, Mom kind of broke it up. The child went off the handle. Mom grabbed the kid in the bathroom, laid her across her lap, and swatted her bottom. The girl went to school the next day and started to cry and showed the school nurse what her mother had done to her. The school knew that she was not doing well in cutting classes, but they had to report. When Mom interviewed with the social worker for the first time, what had happened is that she, it was noted in the social study report that her speech was pressured, and Mom seemed to be tangential in her thoughts. So they went ahead and they filed a petition. The child was left with mother, however, and the question was whether there was sufficient, I can get it for you, harm done to the child to keep it within the system or to remove her from the mother's home. What that kind of kicked off in my head was that there needs to be some kind of contextual and factual distinctions which we need to make when we're looking at these cases. First of all, I know everyone's busy and we're swamped with work, but you need to read case law. You need to look at the elements in statutes. You just do. It'll make your life easier, actually. You won't be so discombobulated or bobulated. Depends if you come from Northern or Southern California. And what you're going to see is that every appellate court case that I've read, almost every one, falls into these four contextual and factual distinctions. There's a precipitating event to analyze. So in Gonzalez, we remember the child was struck with a spoon. In Isabella F., the child was held over the mother's lap and spanked. The result, the harm done, there was still sufficient force to produce visible bruises. Actually, in the Isabella case, the child had marks on her face from fingernails. It was actually determined the child was picking at herself and causing the marks. There was some doubt as to whether Mom had left bruises on her at all, even with the spanking. But those are usually the things that we remember the cases by, like when our clients tell us that they insist on getting hair follicle tests. Those are the cases we remember, especially when the results are as they usually are. But anyway, we need to look at the contents and factual elements. In Gonzalez, that was in the context of CANRA. It was not in the context of a juvenile dependency case. The propriety of recording mother as a probable child abuser pursuant to the CANRA when circumstances present a reasonable occasion for discipline and discipline imposed is reasonable in measure. That's what the court was looking at. The case was not reversed. It was sent back to the trial court to have the trial court make a determination based on the child's actual testimony, which was not heard by the court, to make a determination as to whether there was actually a penal code support for the discipline, where you look at the entirety of the factual circumstances and then, and only then, do you make a determination as to whether the discipline was excessive. It's not just Destiny or the Destiny C, but there is also an Attorney General's opinion, and you should read this just for comparison, so you can see the difference between the criminal intent and then the non-accidental requirement that's in the dependency code under subdivision A. And this is the opinion of the former Attorney General Dan Lundgren. It's from July 21st, 1997. It's number 97-46. Is the official opinion that was sent to one of the state senators. But if you read that, read Isabella, compare it to Gonzalez case, and you'll see quite a bit of difference between the dependency requirements and the penal code. I did the same kind of analysis that you see on your chart, that is looking at precipitating event, results, and the harm done. 3 would be the context and factual elements, which you'll write out for your case, and then the statutory elements and the applied meanings that an appellate court opinion gives to these cases. Like I said, I think it's a good thing to follow. It makes life easier. In the context, we each have about 12 minutes to do this, so I'm going to move fairly quickly now. But I wanted you to at least get what the contextual and factual distinctions are and the analysis process that you really do need to go through. In Drake M, we all remember everyone cites it because if a parent uses drugs and the kid's okay, the case, the petition, underlying petition should be dismissed. Well, there are 4 cases, 2 from 2012, Destiny S and Drake M, 2 from this year, Christopher R and Rebecca C, and they each have some real factual distinctions between them. But more importantly, they deal with different elements of the code. One is dealing with whether there's serious harm, one's dealing with whether there's causation, and the distinctions between them are really important. Drake M, the father argued that, yeah, he gets high, he uses marijuana, but never around the child. There was always somebody to take care of the child. And that he wasn't an abuser is described under the DSM. We need a medical diagnosis for abuse to demonstrate that the individual, rather, is a drug abuser. The court reversed the finding that the child came within subdivision B, and the reason it did so is because the child was okay. There was no demonstration that the father was an abuser, because it focused on abuser, not just because of the DSM, but also because he drove himself to work every day. He did homework with his child every day. His child was not wanting for food. Father played with the child. He was there with his kid. Nothing fit any kind of definition of abuse. That's what Drake M is talking about. If you're going to use causation as the element you're going after, or serious physical harm, Drake M is not necessarily the case to cite to. I put it against, as you can see after I gave the summary of these 4 cases, against Christopher R. That came out of Division 7. It was where the mother was using cocaine throughout her pregnancy. The child was born with positive toxicology for coke and methamphetamines and amphetamines. But what the court was looking at is an abusing mother. There was no doubt she was abusing, although the child had the harm was not just mother's referral, the child's testing positive for cocaine. It's also the resulting harm was a low birth weight, and even though upon release the child had no ongoing health issues, the court, in looking at the 3rd element, essentially conceding dependency jurisdictions, what the parents did was proper as to Brianna. Mother contended the evidence of her sporadic drug use was insufficient to support the finding she was a current substance abuser. The appellate court disagreed. Mom was constantly taking in drugs, ingesting drugs. There was criminal history. The mother, even afterwards, had not continued to attend a program, and she was still showing signs of abuse. The court also came up with an interesting concept. It said, we're not bound by the DSM finding Drake M anyway, because there's no such thing as horizontal stare decisis, which means that each division of the 6 courts, district courts, it's 19 separate divisions, can all come up with a different answer to a similar question. Division 7 kind of saw the DSM as a useful tool in describing an abuser, but rejected it, saying that mom's long history was sufficient to show that she's an abuser, that the child was born under the influence of drugs, that there was a criminal history, was sufficient to show that this child would be at future risk of harm. So they decided that they were going to find that Brianna came within this jurisdiction of the court. The father had also made some arguments, but those aren't real important right now. Destiny S is another drug case where in the course of investigation there was alleged sex abuse of Destiny, who was 11, by some unknown perpetrator. That was found out to be unfounded. The mom opened her mouth and told the worker that she had a history of using drugs. She had used meth and was using marijuana on a weekly basis. She was another one who went ahead and tested anyway. It was found that she was a drug abuser, but she tested positive. But even though an abuser of substances, there was no defined risk of harm from the substance abuse, because once again, the child was a little older, mom was reading to the child was doing well in school, and there was no reason to find a risk of physical, and B also requires a risk of physical harm, and there was none of that. So even though she was an abuser, the other elements of B were not met, and so that's what was argued to the court, and the court reversed any finding as to Destiny S. Rebecca C, again, there was a referral that father and mother used marijuana and methamphetamine in the child's presence. There were gun sales and drug sales going on in the house. Mom relied on the DSM again, saying there was no medical diagnosis that she was an abuser. The appellate court agreed with that. She was an abuser. But again, the elements, unlike in Drake M, wasn't abuse or an identification of the parent as abuser. If you want to correctly use a case to show that there's no causation, then you would rely on Rebecca C. Because even though an abuser, there was no causation between any serious physical harm and her drug abuse, and so the appellate court reversed the finding, again, that mom came within B. The causal connection is what the court focused on, is needed to demonstrate B's serious physical harm element. The only thing to demonstrate that particular element, because you would have sat and read the statute and seen all those elements that are required by the subdivision, is to look at whether there was a causal connection. There was none. I had these last 2 cases, I've used up my time. I brought up San Joaquin is just really, I know, sorry. San Joaquin is,
Lancaster has no sound, so I'm going to put you on our iPhone, on the speaker.
Sorry. Okay. All right, I'm going to continue. San Joaquin's a pretty interesting case. We always, it's more has to do with subdivision B, but when parents come in, we look at who they are. This parent was very emotionally disabled, mentally disabled. She had been one who had been abused, sexually abused by her own father. There was some question whether the child in this case was a result of that interaction, of the abuse. It turned out the father had been prostituting his daughter, the mother in this case, and the child was born as a result of that. But it came to the 18-month date, and it was a question of whether we should go beyond the 18-month date, questioning whether services had been given. The court, had been testimony showing that it wouldn't have made any difference anyway. The psychologists were saying that mothers condition required years more of therapy just to get her to a point where she could deal with her child.